بسم الله الرحمن الرحيم والصلاة والسلام على أشرف المرسلين. We're going to talk about section number 3, notes in the commercial law for business students for Al-Isra University, and section 3 notes on page 141. This is the third type of commercial papers. Definition: a note, often called a promissory note, is a written promise to pay a specified sum of money on demand or at a definite time. Of course, it's in the future. There are two parties to a note: the maker, promisor, and the payee, promisee. For example, for a promissory note, the maker might execute a promissory note in return for a money loan from a bank or other financial institution, or in return for the opportunity to make a purchase on credit. The promissory note includes the following data: A. The order term of the phrase promissory note. It has to be written on face of the note, written on the contents of the note, and in the language in which it was written. B. Unconditional pledge to pay a specific sum of money. C. Maturity date. D. Place of payment. E. The name of whom the payment shall take place or for his order. F. Date and place of creating the promissory note. And finally, G. Signature of the editor. The promissory note, in lack of the said data or the previous article, what we just said before, is not considered a promissory note only in the following circumstances. Again, is not considered a promissory note only in the following circumstances. A. If the promissory note was in lack of the maturity date, it would be considered payable when viewed. Of course, after the maturity date, or if we don't have a maturity date on view. B. If it was in lack of the place of payment or the domicile of the issuer, then where the promissory note was created would be considered a place for payment, and the issuer the editor. C. If the promissory note was in lack of the place of certain of creation, it would be considered created in the place shown beside the name of the issuer, the editor. Well, we're going to move on section number 4, certificates of deposit. Certificates of deposit. This is the fourth type or kind of commercial paper. A fourth type of commercial paper is the certificate of deposit, commonly called a CD. The CD is a written acknowledgement by a bank that it was received money and agrees to repay it at a time specified in the certificate. The first negotiable CD was issued in 1961 by First National City Bank of New York, right now called Citibank. It was designed to compete for corporate cash that companies were investing in treasury notes and other funds. Because CDs are negotiable, they can be traded easily if the holder wants cash, though their price fluctuates with the market. Now we are going to move to section number 5 and talk about requirements for negotiability of commercial paper. negotiability of commercial paper, whether or not a paper is negotiable is the first of our four major questions, and it is one that non-lawyers must confront. Auditors, retailers, and financial institutions often handle notes and checks and usually must make snap judgments about negotiability. The paper is negotiable when meets the following criteria. Number one, it must be in writing. Must be in writing. There is no oral agreement or disagreement in this sense. Number two, it must be signed by the maker or drawer. Three, it must be on an unconditional promise or order to pay. Number four, it must be for a fixed amount in money. Five, it must be payable on demand or at a definite time, of course, in the future. Six, it must be payable to order or bearer unless it is a check. This definition states the basic premise of a negotiable instrument. The holder must be able to ascertain all essential terms from the face of the instrument. We're going to proceed. Analysis of required elements. Analysis of required elements in the paper. In writing. Written or writing includes printing, typewriting, or any other intentional reduction to reduction to tangible form. That definition is broad, so broad in fact that from time to time the newspapers report checks written on material ranging from a griddle to grancy. Since these are tangible materials, the checks meet the writing requirements. The writing can be made in any medium, ink, pencil, or even spray paint, as was the case with the granted check. Of course, there is a danger in using pencil or in ink that can be erased, since the drawer might be liable for alterations. For example, if you write out in pencil a check for $10 and someone erases your figures and writes in $250, you may lose your right to protest when the bank cashes it. Signed by the maker or drawer. Signed by the maker or drawer. Signature is not limited to the personal handwriting or one's names. Any sample executed or adopted by a party with present intention to authenticate a writing will serve. That means that a maker or drawer may make an impression of his signature with a rubber stamp or even an X if he intends that by so doing he has signed. It can be typed or by thumbprint. In some cases, an appropriate letterhead may serve to make the note or draft negotiable without any other signature, nor does the position of the signature matter.